Have any of you ever seen the team of investigators that swoops in after an accident to determine what happened, who swerved, who didn't stop, who missed a sign or didn't realize the impact of their behavior that may have unintended consequences? Well, that crash reconstruction team plays a critical role not only in determining liability of who was responsible for the accident, but also, of course, helping us better understand what we need to do to prevent accidents in the future. Well, litigators are a crash reconstruction team. In law, they look at cases from the perspective of understanding what happened and with practical ways to help us avoid accidents or unintended consequences. So we're very lucky this morning to have Francy and Mark, our litigation crash reconstruction team, here today to look specifically at commercial cases that may impact your real estate practice. Both Francy and Mark are partners in our litigation group with broad commercial litigation expertise that includes, of course, helping clients with real estate matters arising from contractual disputes, joint ventures, purchase agreements, financing arrangements, lease and mortgage enforcement, and more. Before I pass it over to them, I have a couple very small administrative matters to cover. So any lawyers in the room or on the web joining us this morning, these hours will count toward the substantive hours of your Law Society requirement, and you will all have a proof of attendance email after the session that will walk you through exactly how to report it on the Law Society portal. Any clients requiring assistance or help in satisfying any more hours, please feel free to reach out to me at any time. If you haven't signed our attendance sheet at the front, please do so before you leave so we can get that email to you. Today, we would obviously like this discussion to be as practical to you as possible. So if you have any questions as we go, please do feel free to ask them along the way, and we will just get a mic to you so that everybody on the web can also participate and hear your question. So with that administrative stuff out of the way, I'm going to pass the floor over to Francy.
Thanks, Sandra. Good morning, everybody. For today's presentation, we've tried to select topics that are relevant to your day-to-day business practices and particularly cases that may influence how you draft various agreements. The list of the topics that we are going to address is on the slide in front of you. I don't propose to read it in the interest of time. I'm going to start with the first three, and Mark will take it from there. So the first topic for discussion is enforceability of arbitration agreements. On any given day, most of you are dealing with a variety of agreements, be they agreements of purchase and sale, joint venture agreements, limited partnership agreements, purchase and sale agreements, just to name a few. And while not consistently included in all of these agreements, arbitration clauses, or arbitration agreements as they are known, are not uncommon. And whether you have seen these clauses or not, I'm sure you're aware of the perceived benefits of arbitration. For example, confidentiality, expediency, control of the process. And the current rule with respect to the enforceability of arbitration agreements, which was enunciated again by the Supreme Court of Canada in the TELUS case in April of this year, is that parties will generally be held to their agreement to arbitrate, absent clear legislative intent to the contrary. The most recent Ontario appellate consideration of the general arbitration rule was in the case of Electra Utilities and Solar Power, which was decided by the Ontario Court of Appeal in April of this year. The award in that case made by the arbitrator stemmed from what was called a purchase and management agreement, where Electra was to finance the construction of solar power projects which were to be developed and operated by Solar under what was called the Feed-in Tariff Program, the FIT program, which has since been abolished. Solar alleged that Electra had breached that agreement and under the arbitration clause sought $19.5 million in damages for lost profits. The dispute went to arbitration and the arbitrator awarded Solar over $12 million in damages. The agreement specifically provided that there was no right of appeal from the award of the arbitrator. Electra brought an application to the Superior Court seeking to set aside the decision of the arbitrator, and they argued that an award for lost profits was not within the scope of the agreement, and therefore, in awarding lost profits, the arbitrator clearly exceeded his jurisdiction, and that entitled Electra to appeal. And the arbitration judge accepted that argument, set aside the award, and even ordered that Electra pay costs, that Solar pay costs. So Solar then goes to the Court of Appeal and says that the applications judge had no right to do that, that the arbitration clause specifically provided that the determination of the arbitrator was final and binding and it should be reinstated. The Court of Appeal agreed and reinstated the award of the arbitrator, which, as you know, awarded over $12 million in damages. The Court of Appeal concluded that the arbitration agreement gave the arbitrator complete discretion to interpret and apply the terms of the agreement. And therefore, once the applications judge concluded that the arbitrator acted within the authority conferred upon him by the agreement, his task was at an end. It was for the arbitrator, not for the court, to interpret and apply the substantive provisions of the agreement. And Justice Huscroft, speaking for the court, said, "It is of no moment whether the arbitrator did so reasonably or unreasonably, correctly or incorrectly. The decision was the arbitrator's to make." And I just want to go back one slide to show you what the arbitration provision said in that agreement. You'll see that it was extremely broad. Subject to and in accordance with the provisions of this Article 7, any and all differences, disputes, claims, or controversies between the vendor and the purchaser arising out of or in any way connected with this agreement, whether arising before or after the expiration or termination of this agreement, and including its negotiation, execution, delivery. I mean, you can read it, it's all on the screen for you. But the clause made it very clear the breadth of the arbitrator's discretion, and went on to say, and any damages resulting therefrom. So in this case, the fact that the damages included damages for loss of profits was totally within the discretion of the arbitrator. Now, Electra hasn't changed the general rule with respect to the enforceability of arbitration agreements in Ontario. The rule is that arbitration agreements will generally be enforced, absent clear legislative carve-outs. But given this general rule and the decision in Electra, it gives people, real estate lawyers or real estate practitioners, cause to step back and think and take a look at their arbitration clauses. Because it's very clear that if the arbitration clause in your agreement confers jurisdiction to the arbitrator, then the arbitrator will make a determination and that clause will govern. So I think that it's very important that you be mindful of whether or not an arbitration clause is appropriate in the circumstances of the agreement that you're drafting. And a lot of times we come in after the fact when we have to deal with the arbitration clause after the deal's gone sour, and we're asking, well, why did you agree to this and why didn't you agree to that? And I think a lot of times people just cut and paste arbitration clauses from previous agreements, and it's important to consider the specific language of the arbitration agreement and ensure that the language reflects the parties' rights and obligations. For example, as we saw in Electra, they agreed to one arbitrator, and one party thought that the arbitrator acted completely unreasonably, and the applications judge agreed. But that was overturned by the Court of Appeal. So it doesn't matter if he's unreasonable or unreasonable, his decision stands. So you might want to think about whether you want a panel of arbitrators to avoid one arbitrator acting in a way that's unreasonable. We know that Electra was a dispute within the province of Ontario, so there was no consideration to be given to the language, the location, the governing law. But you got to take those matters into consideration if you're dealing not with parties all in Ontario. And typically, if you have a foreign party, particularly in a jurisdiction where you might not have confidence in the court system there, you might want to specifically stipulate there that you're going to have arbitration in Ontario. Another reason for doing arbitration is to ensure confidentiality. As you know, arbitration, the whole process is confidential. If you don't have an arbitration clause, then you're off to court and you could be in the front page of the Globe and Mail. That may or may not be a concern. The other thing that you need to consider is the scope of what an arbitrator can do and whether or not you want to carve certain things out. In this case, the arbitrator was able to award damages for lost profits because that was within his entitlement under the clause. You might want to carve out injunctions. You might want to carve out intellectual property rights. So it's just a matter of being mindful of your arbitration clause, whether you want to specifically stipulate a process for discovery, whether you want to specifically include time frame limitations, and most importantly, in my view, whether you want to have a right of appeal. In that clause, there was no right of appeal, so the parties had no recourse given an unreasonable decision. You may want to provide for a right of appeal, whether it be on a question of fact, a question of law, a question of mixed fact or law. I just think it's important to think about whether you want an arbitration clause, and if you're going to have an arbitration clause, what the scope of that clause is going to be. I want to turn now to the next topic, which is the current state of the law on good faith. As many of you will remember, in 2014, the Supreme Court of Canada came out with its decision in Beseen and Renew. And that case attempted to clarify the obligations of all parties in commercial contracts. And in that, just by way of refresher, because I know at the time it was coming at us from all sides, the court recognized the notion of good faith in contractual performance as an organizing principle in Canadian common law, which encompasses a duty of honesty. Now, the court explained that this was not a freestanding rule, but rather a standard that underpins and is manifested in more specific legal doctrines, exemplifying the idea that in carrying out performance obligations, a contracting party should have appropriate regard to its counterparty's legitimate contractual interests. Now, since Beseen was decided, the Supreme Court of Canada hasn't really had an opportunity to clarify exactly what was meant by its statements in that case, and there have been numerous lower court decisions that have applied it, two of which have gone back to the Supreme Court of Canada on Friday. Both appeals were argued this past Friday. They are currently under reserve, so we're going to see what the Supreme Court determines and whether they provide any further clarification. Just to give you some background, the two cases, one was an Ontario Court of an appeal from the Ontario Court of Appeal, and the second was an appeal from the British Columbia Court of Appeal. The appeal from the Ontario Court of Appeal, it was in the case of Callow and Zollinger. Now, Callow was a company that was owned by Christopher Callow. He was the principal. It was a small company. It provided maintenance services to 10 condominium corporations. Callow entered into, in 2010, he entered into a 2-year maintenance contract for the winter for snow removal. And that was renewed in 2012 for a further 2-year term. And at the same time, there was a separate summer contract that was entered into. So the winter contract that was running from November 2012 till April 2014 contained a provision in it which allowed the condominium corporations to terminate on 10 days' notice. In March or April of 2013, the condominium corporations decided that they were going to terminate the winter contract. That decision was made, and based on supposedly, the position was that the services were unsatisfactory. But they waited until September to tell Mr. Callow that he was being terminated, and in September, they gave him 10 days' notice, which they were entitled to do under the agreement. Now, over the course of the summer, Mr. Callow, of his own volition, performed all kinds of freebies, landscaping work on the property in the hope that this would be an incentive for a further renewal of his winter contract and that he would get an additional summer contract. And the condominium corporation accepted happily the work that he was doing for free, knowing that they were going to be delivering their notice of termination. And the evidence was that they were aware that he was performing this work and that they were aware that he was under the impression that the contracts would be renewed. They delivered the notice of termination in September. Mr. Callow Corporation sues for breach of contract. And so the issue there was not whether they had the right to unilaterally terminate the contract, because the contract gave them that right. The issue concerned the timing of the communication to Mr. Callow and the fact that they had delayed informing him that they were terminating the contract because they wanted to make sure that he completed his summer contract. So he sought damages for what he would have earned under the remainder of the winter maintenance contract had it not been terminated. Goes to trial. And the trial judge agrees with Mr. Callow and says that, yes, Condo Corp, you did breach your contractual duty of honest performance in two ways. In firstly, withholding the fact that you intended to terminate it because you wanted to make sure that he carried out his duties in the summer contract, and in continuing to represent to him that the winter contract was not in danger, and knowing that he was taking on these extra tasks in the hopes and on the understanding that not only was it not going to end, but it would likely be renewed. So the trial judge determined, am I yelling? Sorry. The trial judge concluded that the value of the winter contract was $80,000, subtracting expenses was around $65,000. He threw in the cost of what Mr. Callow paid to lease the equipment, and the award was close to $100,000, and he won at trial. Now, the Ontario Court of Appeal disagreed, and they overturned the trial decision, and they said that, well, the actions of the condominium corporation may well suggest a failure to act honorably. They do not rise to the high level required to establish a breach of honest performance. So the damages award was set aside. Leave to appeal to the Supreme Court is granted. The appeal is argued. We'll come to the argument when I finish discussing the next case that went to the Supreme Court of Canada on Friday. And that was the decision of the British Columbia Court of Appeal in the case of Waste Tech versus Greater Vancouver Sewerage and Drainage. Now, the facts of that case were a bit more complex than Callow. It involved two very sophisticated parties who spent many, many months negotiating a 20-year contract. And that contract dealt with the transport and disposal of solid municipal waste from the Greater Vancouver area. Under the agreement, the Greater Vancouver Sewerage Entity, which I'm going to call Metro, that's what it's called and it's easier to pronounce, they would allocate waste that was to be transported by Waste Tech as amongst 3 disposal sites. And their discretion, they had complete discretion in the allocation of the waste. And the discretionary allocation directly impacted Waste Tech's profit margins, since the compensation to Waste Tech differed between the sites. One was considered a long haul, and the other 2 were considered short haul. Waste Tech stood to make a lot more money if it was a long haul. In 2010, Metro exercised its discretion, and they diverted a significant amount of waste from the long haul to the short haul. Sites, and this redistribution made it impossible for Waste Tech to meet what was called its target operating ratio under the contract. And as a result of the diversion from the long haul to the short haul, the ratio went to 89% costs versus profits of 11%. And Waste Tech argued that the exercise of the discretion in such a manner meant that it was bad faith and that they breached their duty to act honestly by doing that diversion. So at first instance, it goes to the arbitrator. There's an arbitration clause. And the arbitrator says that the agreement had no express term limiting their discretion or saying how their discretion was to be exercised, or giving Waste Tech the right to seek compensation as a result of the exercise of the discretion. And he said that he wasn't going to imply such a term. But then the arbitrator goes ahead and says that despite finding that they only acted, that Metro didn't act that they were acting to further their own objectives. They weren't acting capriciously, and they weren't acting in a manner to hurt Metro. But they said that the arbitrator concluded that the behavior lacked what was called appropriate regard for Waste Tech's legitimate expectations under the contract. And in the arbitrator's view, it was open to Metro to exercise its discretion in a manner that negatively impacted Waste Tech financially, but it couldn't do so to an extent that eliminated any possibility for Waste Tech to achieve its target operating ratio. And so in the end, the arbitrator found in favor of Waste Tech and awarded damages. Goes to the Superior Court of Superior Court of Ontario, Supreme Court of British Columbia. It goes to the Supreme Court of British Columbia, and Justice McEwen overturns the arbitrator's decision. Holds that since the arbitrator decided that he wasn't going to imply a term prescribing how the discretion was to be exercised, he couldn't then argue that there was good faith to be applied to the agreement. So Justice McEwen notably said that you can't use good faith to fill in the gaps that are left by the parties in their agreement. And he said the contractual expectations cannot be the basis of a breach of good faith unless that breach is based on the terms of the contract itself. And notably, there's a quote from Justice McEwen where he specifically says, in the circumstances of this case, the arbitrator attempted to do what was fair, not as grounded in the agreement, but in a more general sense. Beseen is not authority for the proposition that contracts may be adjusted to accommodate situations where one party regrets the contract in hindsight. Basically, you're grown-ups here. This is the deal you made, and you got to live by it. And the Court of Appeal agrees with the outcome reached by Justice McEwen, but with slightly different reasons. Like Justice McEwen, the Court of Appeal emphasized the facts that the parties had explicitly considered and rejected the inclusion of a term in the agreement that talked to how Metro would exercise its discretion, and that this confirmed that WasteTech's expectations of compensation for the effects of the decision were not grounded in the agreement. So the Court of Appeal held that bad faith requires at least a subjective element of improper motive or dishonesty. And the lesson here, as I've indicated as the Court of Appeal and as Justice McEwen said, is that courts are not going to step in to fix a deal or to rewrite a contract under the auspices of bad faith. Both of these cases were argued on Friday, and the Supreme Court of Canada has reserved their decision. It'll be very interesting to see how they come down and whether there is going to be further clarification. So we had the opportunity to watch the argument. You can watch any Supreme Court of Canada argument on the Supreme Court of Canada website. We got a sense of what the argument, we saw what the arguments were. We got a sense of where the court's concerns lay. Basically, in Callow, the crux of the appeal was the extent of a duty to disclose a decision to terminate a contract. Counsel for Callow argued that Callow was misled, that he was intentionally misled, and that silence can be tantamount to a positive representation if it creates a misleading impression, and that by knowingly misleading Callow, the condominium corporation had breached their duty of honesty. Opposing counsel disagreed and argued that good faith was meant to be applied in the context of already existing duties, none of which were here, and that there's a clear distinction between knowingly misleading and failing to disclose. So, and clearly that what the condominium corporation did fell below the threshold of dishonesty. In WasteTech, the appeal revolved around the role of good faith in the exercise of discretion. And WasteTech argued that you have to look at what the reasonable expectations were, and that if the discretion causes a significant impact that is clearly at odds with those expectations, then that can't be good faith. Interestingly, in that appeal, Justice Abella was very vocal in articulating her concern about how could there be a breach of good faith where the arbitrator found that the parties had explicitly considered and excluded a provision that sought to limit the discretion or to make it liable to WasteTech for any adverse effects. And she said that it sounded like the arbitrator had attempted to rewrite the contract by awarding damages for something the parties had specifically sought to exclude. So you know where she's coming from, but it's a panel of 9. And Metro obviously agreed with her arguments. So the implications of these decisions for your practices, for your businesses, the main takeaway here is that litigating all the way to the Supreme Court of Canada is expensive and time-consuming. So you should try to be fair in the execution of your contractual obligations. It's also important to build in protections that you want in the agreement itself. In WasteTech, for example, the parties had engaged expert advisors during the course of the negotiations, and they had considered and rejected the idea of a term dealing with reasonable exercises of discretion. So in hindsight, it probably would have been less onerous for WasteTech to have pressed for the inclusion of at least some metric of analyzing Metro's discretion during the negotiation stage, as opposed to punting the issue and now facing substantial legal expenses. So the point is especially important when you're dealing with complex contracts. It's better for parties to agree to specific terms at the outset, which can be assisted by experts, as opposed to leaving nuanced facts and issues to be determined by the courts. We'll be keeping an eye out for these decisions in the near future. It will be very interesting to see how, and if so, whether the Supreme Court clarifies their determination in Beseen. Stay tuned. My final topic is with respect to estimating potential damages for breach of contract. And I want to refer you to a very recent decision of the Ontario Court of Appeal in the case of Ceramia versus Delco Wire and Cable Limited. That case wasn't a commercial case. It actually was a real estate case. And although the facts are unique, the decision provides insight into how courts will assess damages where a lease agreement is repudiated. As most of you know, and this is going back to Contracts 101, and not all of you are lawyers, but I'm sure you're aware that damages for breach of contract are intended to put the wronged party in the position they would have been in had the breach not occurred. So in Ceramia, the court confirmed that where the contract breached is a lease, damages are determined based on the present value of the unpaid stream of rental payments to the expiration of the lease. In Ceramia, it was a commercial lease. The tenant repudiated the lease, and the landlord couldn't find somebody to release the property and couldn't afford to keep the property, so was forced to sell the property. And it claimed damages not just for the lease rental payments, but also for the lost capital appreciation of the property. So the repudiation of the lease occurred in 2013, but the lease was supposed to go till 2021. And the argument that was made by the owner of the property was, had I been able to hold on to the property until 2021, I would have had the rental income stream until that point, and I would have been able to sell the property for a lot more money. So I should be able to take into consideration the appreciation in value of the land from the time I was forced to sell it because I couldn't afford to carry it to 2021. And at trial, the judge agreed and allowed the landowner, the owner of the property, to realize damages for both the lost rental stream as well as capital appreciation. And there was expert evidence on the value of the land, on how the value would have increased and taking back to present day. So it was a significant damages award. It goes to the Court of Appeal, and the Court of Appeal is asked to consider whether or not it's appropriate for this whole capital appreciation aspect to have been included in the damages calculation. And the court goes through a recitation of how damages are to be calculated. Goes back to the 1854 case of Hadley versus Baxendale. And anybody who is a lawyer in the room will recall that this is first-year contracts. How are damages to be determined? And that case was applied by the Supreme Court of Canada, but it's still followed to today, and as recently as a couple of months ago. So the tests for damages in breach of contract cases there's two branches. You can get damages if they are suffered in the usual course of things. If in the usual course of things, they arise fairly, reasonably, and naturally as a result of the breach of contract, or they were within the reasonable contemplation of the parties at the time of the contract. So at the time the contract was made. Now, remember that remoteness and the whole issue of remoteness, it applies only to the type of loss suffered and not the quantity. So the Court of Appeal held that damages for lost capital appreciation fell outside of both branches. The first branch is objective, and the question is not whether lost capital appreciation was foreseeable in this case, but whether as a general matter and objectively viewed, it's a type of loss that naturally arises according to the usual course of things. And the court found that objectively viewed, the bargain inherent in the lease agreement in Ceramia did not include the opportunity to profit from capital appreciation. There was no way the tenant would have bargained for that the tenant's bargain was to use the premises for trade and commerce, and that was it. And under the second branch, the test was whether at the time they entered into the contract, the parties would have reasonably contemplated that the particular damages would be recoverable if the contract was breached. And there, the Court of Appeal said that there was nothing in the agreement that would support a conclusion that the parties contemplated that capital appreciation would be something that the tenant here would be liable for in the event of a breach. So that gets tossed aside, and the landlord only got the lost income stream. Very briefly, the court then looked at whether or not that was appropriate mitigation on the part of the landlord and concluded that it was. So I am going to turn the floor over to Mark, and I think I've actually done it on time.
More or less. That's 2 minutes late, which by litigator standards is an excellent job. So I'm going to try and run through a series of topics. I'll have to do it rather quickly because I may have bit off a little bit more than I can chew in terms of substance in the time that we have, but we'll see where we get to and hope to get through them all. I'm going to start with limitation and entire agreement clauses. Really common clauses seen in most commercial contracts. So the distinction between the two is a limitation clause seeks to exclude some particular type of liability. An entire agreement clause is a particular type of limitation clause, which seeks to say this is, and I'm sure we've all seen them, although there are different kinds, which we're going to talk in a bit, seeks to say the contract between us is reduced in its entirety to what we have on paper. And there's an irony in it because both limitation clause and entire agreement clauses, their whole purpose is to confer certainty on the agreement. These are my obligations. I have no obligations other than these. But limitation and entire agreement clauses are among the most uncertain in application of any sort of species of contractual clause, in my experience. And the reason why is that they can, on the one hand, have a somewhat unfair result, right? I tell someone something, they rely on it in entering into the agreement. They enter the agreement, the thing I've said turns out to be untrue, and I then hold up my entire agreement clause and say, gotcha, what I told you doesn't matter. And courts, in an attempt to find fairness, don't apply these clauses sometimes. But the effect of that, taken as a whole, is to create uncertainty in these clauses which exist to create certainty. Which is why, as this illustrates, they have to be approached with caution. That doesn't mean that they're not a good idea. They are. But it means that the limits of them should be properly understood. So the framework for interpreting them was settled in a relatively recent Supreme Court case of Turkon. There's a three-part test, which is, first, does it apply at all? And this can be a surprising stumbling block because this is often where courts, and we'll see an example in a moment, this is often where courts impose this idea of fairness by interpreting a clause so narrowly that it excludes something that, if you just look at it on its face, you would think that it includes. The second is it unconscionable in the traditional sense, which is, was it procured in an unfair manner in the first place? And the second is, even if it is not unconscionable in a traditional sense, is there an overriding public policy reason to not enforce this particular exclusion clause or this particular type of exclusion clause? So starting with the first branch of the test, which is, the interpretation point. And in principle, and there are some cases that say the contrary, but what seems to be the majority and the correct approach is that exclusion clauses are interpreted the same way as anything else. I've included here a quote from the recent decision of Good Life Fitness and Rock Developments, which is a 2019 Ontario Court of Appeal decision, which is interesting, and this is a bit of a divergence, but in the sense that this paragraph is, and can fairly be seen as what the Ontario Court of Appeal says is how we should incorporate contracts, or how we should interpret contracts today. And to anyone who read a similar passage 10 years ago, this would look very familiar, right, in terms of the intentions of the parties, according to the language in the written documents, having regard to the objective evidence, but not the subjective evidence. So many of you will be familiar with the decision of the Supreme Court in Satva and how that has impacted contractual interpretation. This passage would indicate that the impact has been not nothing, but it hasn't been a complete change. The issue, just touching on something that Francy mentioned in Waste Tech about negotiations and a point having been specifically negotiated and not included in the contract, one of the main issues in the Good Life case was the impact of negotiations, and the Court of Appeal said prior negotiations, the negotiations that lead up to the contract, are not relevant. So we have there's a lot of talk about the factual matrix. The factual matrix does not, somewhat surprisingly, if you think about it from a common sense perspective, include those past negotiations. So in the Waste Tech example, the fact that the parties had specifically considered and rejected the very term that's at issue would not be relevant according to this. So the limitations can seem, or the application of this test can seem a bit complex, and the equations can be difficult to predict. But breaking it down into its simplest components in terms of predicting how a limitation clause is going to be applied is, first, what does it say? What does it purport to exclude and include? How broad is it? The second, and in this area of law more than most, is who are the parties? Are these two sophisticated parties? Is it one sophisticated party and one unsophisticated parties? And what do the parties do before and after signing the contract? And we're going to see an example. The best entire agreement clause in the world is worth very little if it's in any way hidden or not specifically, and in some cases, not specifically brought to the attention of the purchaser. But I want to use an interpretation point. So this is a 2019 decision of the Ontario Court of Appeal, Gendron and Doug C. Thompson Limited. So Gendron is a homeowner. Doug C. Thompson Limited delivers fuel used for heating Gendron's home. It spills. When it's delivered, there is a quite significant spill. Gendron, instead of calling anyone, tries to clean it up using cloths and Tupperware, and says to himself, I got it all, and I'll go to bed now. Goes to bed having filled up a couple Tupperwares full of heating fuel. The next day, wakes up, looks at his tank again and says, wait a minute, I was supposed to have 700 liters of heating fuel, and my tank says I only have 100 liters. So you, Doug C. Thompson, have shorted me by 600 liters. Calls Doug C. Thompson to complain about this, at which point somebody realizes that 600 liters of heating fuel have leaked into the ground, which I'm sure all of you can appreciate is a nightmare. What follows is $2 million worth of remediation costs because it's leaked into the groundwater. The $2 million doesn't include the cost of tearing down Gendron's home so that the soil underneath it can be cleared, and then presumably rebuilding it. So Gendron sues Doug C. Thompson Limited. And the crux of the lawsuit is that Thompson has a regulatory obligation to inspect the tank and to only deliver fuel if it is satisfied that the tank is safe. And Thompson Fuels claims to have conducted an inspection, but can't find the inspection report. So, another aside about the importance of good record keeping. Who knows if this inspection actually happened? If it happened and then somebody lost the report, that's a very costly mistake. But Thompson Fuels does have the benefit of this limitation and liability, which says Thompson Fuels is not responsible for the inspection and or maintenance of any fuel or oil tank, which is, on its face, the very thing that it's failed to have done is inspect the tank. Then it says it's not liable for any injury or damage to any person or property resulting from the existence and operation or non-operation of any oil-burning installation on the premises. Again, on its face, it seems broad enough to capture this situation. But it also goes on, and this was a caution about excess verbiage in these, because it says at the last sentence that it will not be liable for any damage caused by furnace failure while your residence is vacant, nor any special or consequential damages resulting from Thompson's failure to perform its obligations under the contract. So this opens the door a little bit. If you're not liable for special or consequential damages, by implication, maybe you are liable for ordinary damages. In the result, Thompson is found liable for remediation costs. And the reason why is because, and this is how the interpretation is sort of, I would suggest, imports a bit of a fairness requirement. The clause doesn't specifically exclude a failure to abide by its regulatory obligation to inspect, right? And if you look at it again, it says it's not responsible for the inspection and or maintenance. So many of us in the room would say that includes all inspections, regulatory or otherwise, and the courts at both levels disagreed. And the second branch was that it was contrary to public policy because Thompson had a regulatory obligation, it couldn't exclude that obligation from its contract. But again, keep in mind the context that Thompson is relying this on. This is not in defending a regulatory proceeding, which had occurred. This is in a civil action brought by a customer. But still, it was found you can't exclude tort liability. So this shows the precision that is required in drafting an effective limitation of liability, that you really have to consider all of the ways, or as many of the ways as possible, that that liability could occur, and try and be specific as possible in addressing them. There are other cases, for example, where parties have excluded liability for representations, which we'll talk about in a minute, but not specifically said negligent misrepresentations. And it's been held to exclude, that's been held to not be specific enough to exclude liability for representations. Now, again, if you think about it from a common sense perspective, a representation that is not negligent, and you can't exclude liability for fraudulent misrepresentations. So if something's not negligent, it's not fraudulent, there is no liability and nothing to exclude. So you would think that liability for representations would exclude, but the courts have found otherwise. So I want to talk briefly about entire agreement clauses, which are a species of limitation clause. And I want to break them down into three broad categories that often get mixed together. Sometimes you see them in the same clause, but they're different and apply to different, address different issues. So the first is a written agreement clause, which says, in effect, there are no agreements other than the agreement that's in this contract, right? So what it is targeted at is a breach of contract claim based on an oral agreement or an implied agreement. There's a no representation clause, which is similar but slightly different, which says, in entering into this contract, I have not relied on any representation. So that is targeted at a misrepresentation claim to say I was induced to enter into this contract by a representation. And the third, which is less common, but a written amendment clause, which says this agreement can only be in writing. This agreement can only be amended in writing. It can only be amended in writing. Sometimes it will say signed by both parties. And the effect of that is to say, I can at any given time turn to my contract, open it up. As long as I have all the amendments, I can always know what my obligations are. The difficulty sometimes is in the enforcement. So a couple of things to consider when looking at one of these is what specifically is being excluded? What problem is being addressed? Is it only collateral agreements? Is it representations? Who could have made representations? So for example, in the real estate context, we often see real estate agents as the party who made the representation that's at issue. And if that is a possibility, it's something that ideally is addressed. And when is the entire agreement clause going to apply? Because in the ordinary course, an entire agreement clause is spent once you sign the contract. So it can sort of wipe the slate clean and say there's no representations, no collateral agreements as of the date of signing. But if you have a long-term agreement, a lease or a joint venture, then that has to be addressed. So an example of what not to do comes from the case of Singh and Trump. And in this case, in fairness, I have to say, the misrepresentations were not, from what I can tell, made specifically by Donald Trump. But it applies, and I really liked this picture, so I included it. Singh and Trump was a condo development sold next door to here. Some of you may have parked there. It's now a St. Regis. And the development, sidebar, but the valet parking at the St. Regis costs the same amount as day parking under our building. So next time you come, I would recommend it. The agreement in Singh and Trump was a hotel development sold to essentially investors on the idea, at least in part, on the idea that they could contribute hotel rooms into a pool which would be rented out and could generate profits. And the evidence was, and the facts are relatively complicated, but a representation had been made to the Ontario Securities Commission that these were not to be sold as investments. They were only going to be sold as, hotel units or condo units that you could live in and sort of rent to defray the cost. That doesn't seem to have been what happened. The significance of it, though, is that if you look on its face at the agreement as drafted, and there were actually several in the various documents people were asked to sign, saying there's no representation, no warranties, no collateral agreements, the clauses as drafted are as well drafted, as comprehensive as anyone could want. So the lawyer who drafted them did fine. The problem is they were then given over to a team of agents in a sales center who sold everyone fairly explicitly on the idea that you could make money off these condo units. And as a result, these were not enforced and they were unenforceable. And the Court of Appeal, so at first instance, the disclosure documents and the entire agreement clauses were enforced and the plaintiffs failed. But the Court of Appeals said that they, and I quote, functioned as a trap to these unsurprisingly unwary purchasers. The purchasers happened to be very unsophisticated, at least the representative purchasers, very unsophisticated parties. And the finding was essentially these were buried deep in legal documents that nobody could reasonably expect these folks to have read, so they will not be enforced. This contrast, but this shouldn't be taken as a finding that limitation clauses and entire agreement clauses won't ever be enforced where there's an imbalance between the parties. And as an example, there's the Berkshire and Government of Manitoba, which is a recent Manitoba Court of Appeal decision, which is a dispute between a farmer and the Government of Manitoba. And there was a power imbalance or a sophistication imbalance, and it had to do with a fairly complex fact pattern about what the government would or wouldn't do to stop land that it leased to Berkshire from flooding. And in that case, despite the fact that there was a power imbalance and there was no evidence that the clause had been specifically brought to his attention, the plaintiff was found to be an intelligent man, and that's a quote, who had been engaged in the farming business for many years, and the clauses were enforced in accordance with their terms. So if you take these two together, you wind up with a rule that's not very satisfactory, or a conclusion that's not terribly satisfactory in terms of structuring your affairs, that these are good to have, but not always enforceable. Next, I want to talk a little bit about the corporate veil and the piercing of the corporate veil. I hadn't thought about this in a long time, but the veil is an interesting metaphor for the corporate, the fact that it's the corporate veil and not the corporate wall or the corporate sort of steel curtain is an interesting metaphor, because I think for most of us who practice in commercial litigation and other areas of corporate law, we see the corporate veil as very strong and very difficult to pierce. And that is true for the most part, but there are a couple of recent decisions that cause some concern. So the first is in the context of oppression. Okay, so the oppression remedy is available under various corporate statutes. It's also available under the Condominium Act. And it's a very fact-specific test when oppression has occurred. You have to prove that somebody had a reasonable expectation, that the expectation was breached in a way that was unfairly prejudicial to the allegedly oppressed party. And the reason why this is important is because oppression claims are very hard to get rid of at a preliminary stage because they're so fact-specific. It can be done, but it's difficult to do it. And so then the question is, when can you reach through the corporate veil in the context of an oppression remedy? So this was articulated in Wilson and Al-Harayeri, and the test is essentially that conduct has to be attributable to the director of the corporation, and it has to be fit in the circumstances. So basically, a director that is participating in a decision is implicated in the oppression. And the second branch of the test of fit in the circumstances is, as the Supreme Court noted, very amorphous, right? When is it fit in the circumstances? That is something that is not yet well fleshed out in the case law. And this is a cause for concern, because is the test for the for personal liability under the oppression remedy less strict than the ordinary test? And the answer to that is not yet clear from the decisions post-Wilson. But one example is Dunn and Burdett, which is an Ontario Court of Appeal decision. Dunn and Burdett is the result of a 35-day trial, giving rise to a 128-page decision relating to a condo board dispute. So those of you considering serving on condo boards should keep that in mind. But what I wanted to highlight here is not the facts of the case, which are quite convoluted, but Dunn and Burdett at the Court of Appeal level includes this quote, which says, "Whereas here it is clear that a director is the motivating force behind the oppressive conduct, he or she should be held personally liable." So if you think about that in a lot of real estate contexts, there will be a closely held corporation with one or two directors. It is hard to imagine those directors not being the motivating force behind conduct. By definition, they need to be. So this, and I don't think that the Court of Appeal meant to articulate the test quite as broadly as it seems here. But one could take this passage and spin it into quite a liberal approach to personal liability. The second more traditional case that I wanted to touch on is the notion of a directing mind, which is again something that would go back to the traditional test for law school. And this is another recent case. It's a trial level decision between two numbered companies. What's significant about it is that the setup of the transaction itself was fairly standard. The plaintiffs submitted or paid 40% of the cost to acquire a commercial property being managed by the defendant company. Okay, and all of this was done. The setup would be familiar to most in this room. There ought to have been a co-tenancy agreement. It was never signed, but that's not what's important about this case. The plaintiff sold the property, didn't tell the defendants, kept the proceeds, and bought another property. And the plaintiff's principal was held personally liable for the resulting damages. And what's important, though, is that in the reasoning of the case, it's fairly clear that the reason why personal liability is imposed is because something terrible happened. But the case isn't specifically confined to that, right? So there's an open question because the person was said to be a controlling mind and the sole shareholder, and personal liability was imposed because the plaintiff's company took the defendant's funds and agreed to use them in a particular manner and then didn't. But again, that structure in itself is not uncommon. So the open question is this expanding personal liability for directors, or is this just driven by the fact that the person who was found liable was a bad guy? So a couple of things to keep in mind. The corporate veil, one, establishing separate existence is important here, especially oftentimes you have an owner company and an operating company, and that's another important distinction to keep in mind, and avoiding facts that could give rise to a finding that either the principal or the operating company are really controlling the owner to fix with liability, and following sort of corporate niceties or formalities can also help, together with appropriate indemnities, insurance against personal liability claims. I have no time left. I am now going to just tell you about my last two topics in less than 30 seconds. One is the decision of Canadian Home Publishers and Parker. The import of it is this. In a limited partnership, the limited partners do not share in the residual value of the assets on dissolution. So limited partnerships are often structured so that the limited partners get all of the profits. The decision in this case is that that is not true on dissolution, and that the asset value on dissolution goes to the general partner, which it would be a surprise in the way some real estate joint ventures are set up. The last topic that I plan to touch on, which I suspected from the outset I would not, are some new developments in limitation issues, which will have to get left for another day.
Questions in the room that anyone has that we can answer? The speakers will also stay with us a few minutes after if there's anything, and we'll be circulating the list of
There's a question over there.
We have a question.
We have a question
questions
over
or
there.
cases cited after.
First of all, thanks very much for the wonderful presentation. While you're doing presentation, you also forecast something to us here. You said that with the decision December 6th, the Supreme Court heard two major decisions, correct? Once the Supreme Court released those decisions, will you host another seminar like this again? Invite us to come back for another seminar like this? That's my question to you.
Sandra's in charge.
We'll do something.
We will do something.
We will definitely keep you posted.
we will definitely do an update that will get out to everybody that will advise of the decisions. I suspect it will. I mean, the general turn is around 9 months from the time an appeal is heard until the time a decision comes. So I don't expect that we're going to be getting an answer anytime very soon, but we'll definitely keep an eye out for that and keep you posted.
So first, thanks for a great presentation. I'm not a lawyer, so this may be very obvious to the rest of the room, but in commercial lease transactions, there's typically an offer to lease that is a binding agreement that is conditioned on or expected to be followed by a lease agreement. As it relates to the limitation clauses and good life, how is discrepancies between the offer to lease and actual lease document dealt with?
So that's a difficult question, and actually that's a live issue in a trial that I just finished, and I'm arguing. Typically, the lease agreement would explicitly supersede the offer to lease to the extent that there are inconsistent terms. That's usually what you see. Where that doesn't happen and there are inconsistent terms, again, you would usually, the first thing the court would do is try and find a way to fit them together, right? If they say they both apply, try and find a harmonious interpretation. If that can't be done, then typically, again, the agreement to lease would govern, but not for certain. There are times where it doesn't, with surprising outcomes.
Just given our time, again, our speakers will be around if there's any other questions, but we thank you all for joining us this morning. Thanks so much.
Thank you.